Good afternoon. It's 1 p.m. so we will start our webinar. Good afternoon to all participants. I see that there are still participants coming in, but nevertheless, I propose that we start our webinar. Welcome to our webinar on recognition and enforcement of arbitral awards in Africa. Practical perspective from Nigeria, Kenya, and Ghana, organized by the Chartered Institute of Arbitrators. Very active not only in the UK and in Europe, but also especially in Kenya and Nigeria. Why did we choose this subject? When starting an arbitration as a lawyer, you already have to think about how to enforce the arbitral award. I mean, even before starting the procedure, you have to think about what are you going to do in case you win and in case the opponent is not paying and you have to force him to pay. So knowing how to enforce the award is essential. On paper, it looks quite easy because the New York Convention facilitates the enforcement of arbitral awards all over the world, and all countries present now in this discussion, Nigeria, Ghana, Kenya, and Germany, have signed this convention. So that's why we chose this subject. Why does a German lawyer, and I'm a German lawyer, organize a conference with lawyers from many important countries from Africa? Well, I'm based in Germany. I'm handling arbitration proceedings in Germany, but of course, sometimes I do have to enforce them in other countries, or colleagues from other countries want to enforce an arbitral award in Germany. So it's an international business. And for many years, I'm cooperating with African lawyers. And those who are on the panel, I met them a couple of weeks ago in Arusha, Tanzania, where I organized a conference. And Darlington was one of the participants, Quaco was another participant, and a partner of the firm of James and Irene also were participants. So we said, well, why don't we have a webinar which shares knowledge about how to enforce arbitral awards in these African countries. So I'm not going to speak on how to enforce an arbitral award in Germany. This is not the topic of today's webinar. I'm only the moderator, but I will present to you several African lawyers experienced in enforcing arbitral awards, because knowing what's in the New York Convention is not enough. When going to enforce an arbitral award in any given country, you have to know how does it work in this country? What are the rules in place? What is the practice? Because yes, you're fine with arbitration, but when it comes to enforcing the award, you need the state courts. So you have to know how does the procedure work with the local state courts, which court is competent, how does it work, what are the defenses, what are the costs, how long can it take? All this kind of practical questions is of utmost importance. So that's the introduction to our webinar. Some housekeeping rules. How are we going to proceed? First, the two lawyers from Kenya will present, and I will introduce them to all participants. Secondly, it will be Darlington from Nigeria who presents, and third but not least, Quaco from Ghana. So, and before each presentation, I will present to all participants the presenters. After the presentations, all participants may ask questions. Zoom has a question and answers button. So I suggest, for the convenience of all, that those who have a question ask them in writing using the questions and answers button. And I will have a look at these questions coming in, and the presenters will, as far as possible, answer them. There's also a button which enables you to raise your hand, but as we have quite some participants, I would prefer to get your questions in writing because we only have 1 hour for this webinar. So too much discussion may not be possible, but nevertheless, please feel invited to share your thoughts and your questions with us. Having said this, I propose that we start. We start with recognition and enforcement of arbitral awards in Kenya. And we have 2 presenters. It's James Tuji. James Tuji has over 8 years experience as an advocate in Kenya. He's a partner at Munyao Mutama Kashindi. He's also a lecturer at the Kenya School of Law. James has over the years been involved in some of the most significant litigation in Kenya, involving novel points of law, serious constitutional and legal issues, and matters of public interest. In the alternative dispute resolution space, he represents clients in ADR processes and also sits as an arbitrator and a mediator. He's a fellow of the Chartered Institute of Arbitrators. The floor is yours, James.
Thank you, Professor Hamann, and good afternoon to all the participants. We have a fairly short time, so we will basically be giving an overview of the practical perspectives of enforcement of arbitral awards in Kenya. We have split our presentation into 3 subtopics. We will first talk about the procedure for enforcement. We will then talk about how to stop enforcement, so basically the defenses to the enforcement process, as well as the setting aside of arbitral awards. And finally, we will talk about the cost implications in the processes. I will cover the first 2 bits, and as I do that, I will talk about both international arbitral awards as well as domestic arbitral awards. With regard to enforcement of awards, I think it's important to note, and Professor Hamann mentioned it earlier, that Kenya is a contracting state to the New York Convention. And that's an important fact in terms of recognition and enforcement of foreign awards. I might also mention at this stage that generally Kenyan law on arbitration is pro-enforcement and pro-arbitration. When we discuss further, you will see that there have been some recent developments that could be construed to sort of affect that, but generally Kenya still remains a pro-arbitration and a pro-enforcement jurisdiction. Our local arbitration law, that's the Arbitration Act of 1995, is also largely modeled around the model law. So again, in terms of progressive ideas on arbitration and in terms of the substantive provisions, it looks a lot like most of the domestic arbitration legislation in most of the other countries that use the model law. Having said that, now, if you'd like to enforce an arbitral award in Kenya, in terms of procedure, there's not much of a big difference between the enforcement of domestic awards and foreign awards, provided, of course, that the state from which in which that award was made, so that is the seat of the arbitration, is a contracting state also to the New York Convention, or has an agreement or a treaty for enforcement or recognition with Kenya. In terms of procedure, you are supposed to file in court the arbitral award itself, the original of it, or a certified copy. You're supposed to file as well with that the award, the arbitration agreement, sorry. Again, either the original or a certified copy of that agreement. And in the event that either of those is not in English, especially the award, then you're also supposed to supply a certified translation of it into English. That largely mirrors what you also see in the New York Convention. It's also in the Arbitration Act. Procedurally, what you are then supposed to do is to file an application. The Act says in the High Court, but in certain instances, this has been construed post 2010 to also include the two other courts that are of a similar status as the High Court. But this will largely affect domestic awards. In terms of international awards, most of them will get filed in the High Court for enforcement. Irene will talk about the cost implications, so I will not talk about that. But once you have filed your award, the party against whom you wish to enforce the award is allowed an opportunity to object to the process of enforcement. So you are required to serve this application upon the party against which enforcement is sought. They are notified of this process and they have an opportunity to respond. There are various grounds which we would then sort of call the defenses to enforcement. You will notice that these grounds for refusal of enforcement are largely similar to the grounds for setting aside of arbitral awards as well. And they revolve around, I will not go through them one after the other because they are really the grounds you see in the New York Convention, but they revolve around the capacity of the parties in the first place to have entered into the arbitration agreement. They revolve around the jurisdiction of the tribunal at the time the award was made. So if the tribunal was not set up in accordance with the arbitration agreement, they revolve around issues of arbitrability of the dispute, and there are as well public policy considerations. I will talk a little bit about the public policy considerations, especially with regard to foreign awards, because sometimes what might happen is what is fairly acceptable in another country in terms of their norms and their traditions, which would then probably lead to a proper commercial engagement that may lead to an arbitral award, could well be something that in a different jurisdiction is considered against public policy and may well lead to an arbitration agreement, an arbitral award, sorry, that was based on that contractual arrangement being set aside. And a lot of applications for setting aside arbitral awards, as well as for refusal of recognition, are actually based on public policy considerations. The argument that that award goes against the public policy of Kenya. The other reason maybe that this ground is relied upon a lot is because there's some flexibility in the interpretation of what amounts to public policy. And so it probably is an easy ground to argue or to attempt to argue if you want to try to defend the enforcement of an award. Because of time constraints, I'll probably just mention that practically in terms of what you file, you are expected to file an application. It's by chamber summons. That application is ordinarily accompanied by an affidavit, which would then be the document through which you produce the arbitration agreement, the arbitral award, and if there's need for translations, then you'd also produce it through that. I will cede the rest of the time to Irene, and if there's any time left when she's done with the cost issues, then I might come back.
Thank you so much, James. Before starting, Irene, let me briefly introduce you. Irene also is a partner of the same firm than James. She's an advocate of the High Court of Kenya with 14 years post-admission experience. She specializes in commercial and civil litigation and has an extensive sub-specialization in employment and labor relations, tax, and public procurement. She's also adept in arbitration and an associate member of the Chartered Institute of Arbitrators, Kenyan chapter. She has represented parties and also acted as an arbitrator in local and internal arbitration, including LCIA and ICC arbitrations. She's a board member of the Public Procurement and Administrative Review Board, and she's very well placed in many national and international rankings, such as Chambers and Partners or Legal 500. Having said this, please give your presentation, Irene.
Thank you very much. I'll barely spend 2 or 3 minutes because I see our time is gone. Maybe I just need to mention one thing before I go to cost, which maybe James was not able to mention because of time constraint. But I can see our Kenyan colleagues online, and maybe we need to be remiss on us on not to mention one issue that James had alluded to, which is recent jurisprudence from our Kenyan courts, especially the Court of Appeal, actually the Supreme Court, about the court's role in arbitration and intervention by the court in arbitration. And this has to do with whether the appellate courts can interfere with decisions of the High Court or the other courts of equal status, as James has mentioned, when it comes to setting aside judgments. So we've had about 3 cases, New2 versus Agrovet. I'll just mention them, but if you need us to give citations in full, we are happy to do that for those who are not Kenyan practitioners. There's a Geochem case, there's a Synergy Industrial Credit Limited case, which are fairly the main cases that have discussed the issue. And what the Supreme Court has said that in certain circumstances, in cases relating to applications for setting aside, there could be a limited window for appeal from decisions from the High Court to the Court of Appeal. Previously, before 2019, before the first case was decided, that the New2 Agrovet case, it will not be possible. It will not be possible for parties to appeal from the High Court to the Court of Appeal and possibly to the Supreme Court if that is possible. But now the courts have clarified that in very limited circumstances where it can be shown that a decision by the High Court is so grave, is also manifestly wrong, and which has completely closed the door to justice, then the Court of Appeal can grant leave for an appeal to be made from the High Court to the Court of Appeal. And I think that's what James was saying, that these cases have been, some of these cases have been criticized as to opening the door to intervention by the court. But I think another school of thought has been that it's still okay, such that when there is grave injustice, the court can still intervene. So having said that, let me deal with the issue of cost before I cede ground to my other colleagues from other jurisdictions. I'll cover it in 3 quick grounds. One is court filing fees. Court filing fees for an application for enforcement is Kenya shillings, 10,000 shillings, where when you're presenting your award, which is roughly equivalent to about $80 to $100 based on the current exchange rate. For an application for setting aside is Kenya shillings 2,500, just a little amount there of about 25 USD. But of course, if there are any other subsequent filings and what have you, there could be small fees of filing submissions and what have you, but nothing major. So that is in as far as court filing fees are concerned. But of course, we have lawyers' fees, and if you're coming to make an application in a Kenyan court, whether for enforcement, of course, you'd have to use a Kenyan lawyer who is allowed to practice in our Kenyan courts, and then your fees would be depending on the nature of, depending on the quantum and really the nature of the matter. You can agree fees in 3 main ways. One, as per our scale fees, which are set out in our advocates remuneration order. I think that's usually a common practice in most jurisdictions where there are scale fees. Or you can agree on a lump sum, or you can agree on an hourly basis. So any of those 3 is what is commonly adopted by parties and their lawyers to represent them in such an application, either enforcement or setting aside. Lastly, of course, there would be the party and party costs. I think it's also a common issue in most jurisdictions where, and we usually follow the common law, the popular common law principle of party, what is it called? Cost follow the event. Cost follow the event, so such that most of the time the losing party would be the one to pay the cost, unless of course the court can determine otherwise in as far as costs are concerned, because it's a discretionary issue. So if costs have been awarded, so we'll have the party and party costs that are also determinable as per our scale fees under the advocate's remuneration order, which is also based on the value and the nature of the subject matter. I think I'll stop there for now. Thanks.
Irene, thank you so much. Before handing over to Darlington, I would present 2 questions, or even 3, to the Kenyan team, because I already received a couple of questions from a German colleague based in Hamburg. There are 2 questions to you, James. Could you give an example of an award which was set aside in your country for public policy reasons? The background may be, in Germany, parties often claim that there are public policy reasons, but in most cases, German courts don't accept these reasons. So the success rate is not very high. How about Kenya?
So it's actually much similar. A lot of arbitral awards actually end up getting enforced. There have been, in fact, cases where, despite the arbitral award lacking some formal requirements, such as it's not dated, it's probably not signed, there are some curious cases where an arbitral award is enforced even though it lacks in some material respects. I am trying to get a specific example, and perhaps I could get back to that question at the very end of the presentation. But by and large, both domestic and foreign awards are largely enforced, which is why I mentioned that Kenya is largely a pro-enforcement jurisdiction. I saw that there was also a question about time.
Yeah, how long do enforcement proceedings of international awards usually last?
Yes,
There's
so it depends
some rough estimate or some experience.
Yes, depends likely on whether there's an objection to the enforcement. If there's no objection and it's just a question of filing the application and there's no response to it, you're probably looking at around 3 months. If there is an objection, you're looking at maybe 6 months to 1 year, hoping that there is not a lot of other, applications filed in between, or other factors. But I think if you work with a period of 1 year, you are probably getting your enforcement done, even if there's an objection.
Thank you, James. There's also a question to you, Irene. Are there special programs in your country to advance women in arbitration? It's a big issue in Germany right now. How about Kenya?
There are no formal organizations per se, but we have some informal discussions and arrangements and groupings. I've heard about women in arbitration. So they're not very formal, but there's actually been a recognition that we need to come together to support each other, and also our counterparts were from the male gender to also support each other. So nothing formal, but some informal structures here and there. And then maybe I'll just take that opportunity to give one example to just on the question that was asked to James, is that I know of a case of, it was Tanzania National Roads Agency versus Kundan Singh Construction, where the court refused to recognize an international arbitral award because the applicable law that the arbitrator used was wrong, was not the applicable law that the parties had agreed to. So he applied English law instead of Tanzanian law, and then the court rejected that application on a number of grounds, and even public policy was mentioned as one of the grounds that was considered.
Thank you for this
from me?
information. Yeah, very good. Thank you, Irene. It's time to travel from Kenya to Nigeria. And it's Darlington of Keze who's going to present. He's a managing partner of Onyx and Bricks based in Port Harcourt, Nigeria. I visited him there some years ago. Darlington has extensive experience in dispute resolutions, litigations, arbitrations, and mediations arising from commercial contracts, labor and employment issues, tax liabilities, compensation claims, and property disputes, claims arising from oil exploration activities and negligence. He also had responsibility for company formations and restructurings, joint ventures, public-private partnerships, transactions, real estate investments, particularly with regard to contractual issues. He's admitted to practice as a barrister and solicitor of the Supreme Court of Nigeria. He's a member of the Nigerian Bar Association and the Chartered Institute of Arbitrators UK Nigeria branch. And now we are curious and impatient to listen to you. Darlington, go ahead, please.
Thank you very much, Professor. Okay, let me just go straight. None of time constraints, I'll just dive into the subject matter of the paper. But first of all, I'd like to just enumerate the legal framework governing recognition and enforcement of arbitral awards in Nigeria. Now, the main legislation governing recognition and enforcement of awards in Nigeria is the Arbitration and Conciliation Act. It's the Nigeria. We also have the Foreign Judgment Reciprocal Enforcement Act. It's an act of the National Assembly mainly for enforcement of foreign judgments. However, the definition of judgment in that act includes arbitral awards. So it's also used for enforcement of arbitration awards. There's also the International Center for Settlement of Investment Dispute Act. There's also the Lagos State Arbitration Law. Now, in Nigeria, Lagos is our commercial, which in essence, the provisions are similar to those of the Arbitration and Conciliation Act. Now, there's also the Sheriff and Civil Process Act. This is basically for enforcement of award. The other legislations I've listed earlier on deals with recognition of the award. But when it comes to enforcement, which is the execution of the award proper, we take reliance is made on the Sheriff and Civil Process Act. Now, because the subject matter of our discourse is international arbitration, I will just limit ourselves to the regulations that deals with, that are necessary when it comes to enforcement of international arbitral awards. There are two of them, basically the Arbitration and Conciliation Act and the Foreign Judgment Reciprocal Enforcement Act. Now, by virtue of Section 51 of it says an arbitral award shall, irrespective of the country in which it is made, be recognized as binding and subject. Now, by that provision of the Arbitration and Conciliation Act, an international arbitral award is enforceable in the same way domestic award is enforced. Now, Section 54 of the same act also recognizes the New York Convention. So by the ACA, you can either enforce under Section 51 or under Section 54. So if the international award is not from a contracting party to the New York award, you can also still enforce via Section 51, which allows enforcement of international arbitration as if it were a domestic award. Now, in terms of procedure, the procedure of courts, because the ACA defines courts when it says an application to the court to be the Federal High Court, the State High Court, and the High Court of the Federal Capital Territory. Now, to put this in perspective, in Nigeria, we have the state courts and the federal courts, which have different jurisdiction. Both of these courts, depending on the location of the defendant who you seek to enforce the award against. Now, the procedure for enforcement is not determined by the relevant rules of these courts. So, for instance, the Federal High Court rules, the procedure is you file a motion ex parte, attach the affidavit and written address. Now, in the affidavit, you need to exhibit the arbitral award, the arbitration agreement, and its translation if the award or the agreement was not originally in English language. However, the court has discretion to ask that the other party be put on notice. In the Lagos rules, you file an originating summons, which is like an originating process. in most of the other state high courts, a simple motion on notice would suffice. Now, in terms of application to set aside, as it applies in Kenya, it's same grounds for setting aside that the court also uses for refusal, though by two different provisions, and it all boils down to same thing and applicable in the New York Convention, issue of capacity
Arlington, we do have a technical problem. I can't hear you.
jurisdiction
Now you are back.
on misconduct of the arbitration of the arbitrator, public policy. Under the like I mentioned, it's meant, which however defines foreign jurisdictional arbitration awards. Now, what did you lose? Hello, hello, can you hear me? Can you hear me? Hello, can you hear me?
I can hear you now, but please speak not too fast, because then it might get problems with the technique.
Gospel, can you hear me? Okay. So, okay. Like it appears you lost me at the point.
I can't hear you clearly.
Can I go ahead?
Darlington, there is a technical problem. I can't hear you.
Oh, is it better now?
Yes.
Is it better?
Yes, it is.
Wow. Oh. Okay. Okay, so I can go ahead.
Please go ahead.
Oops. Can I go ahead?
Yes, please go ahead. Darlington, can you hear me? Let's look.
Go ahead. Okay. I think the network got a bit unstable. Now, under which defines foreign judgment to include an international arbitration award. Basically, what you have to do is just to apply for registration of the award. And the process of registration is governed by the relevant rules of courts. And it's similar with what is allowed under the application, even if you're applying under the Arbitration or Consolation Act. It's either you're filing via a motion ex parte, which the court can ask that you put the other party on notice, originating summons, or originating motion. As I mentioned earlier on, there's also a provision for setting aside, even if you apply under the Foreign Judgment Reciprocal Enforcement Act. And it's also borders on issue of jurisdiction, fraud, incapacity of parties, and all that. They're quite a long list. I won't be able to run through them. Now, there's also recognition and enforcement under the International Center for Settlement of Investment Disputes Act, which Nigeria is a party to that ICISD convention. Under that act, it's the Supreme Court that has original jurisdiction for enforcement of such arbitration. However, from available records, that procedure has not been applied in Nigeria. I should also mention that our case laws also support the filing of a civil suit for enforcement of arbitration under the principle of obligation. Now, after you filed, the court has granted you leave to either register the award or enforce the award. You now have to go through the enforcement procedure. Now, by the Sheriff and Civil Process Act, there are various means of enforcing or executing the judgments. You can either go via the writ of a FIFA or garnishee proceedings, which are basically for monetary judgments. Now, the procedure under Register of Courts, stating the name of the judgment debtor and his address. The register assesses the court process and advises you on the costs. You pay the requisite fee, and the officer, the sheriffs of courts, go into the property to seize and detain the goods, and thereafter sell within 5 days if the judgment debtor do not pay the judgment sum. And I'm sure that garnishee proceedings is a global proceeding, so I think we all know how that works. But however, in Nigeria, it's basically first by filing a motion ex parte against the garnishees will not be made absolute.
Darlington, you are mute. I can't hear you anymore. Darlington, you're muted. I can't hear you anymore. Darlington, can you hear me?
Yeah, I can hear you, sir.
Okay, because I couldn't hear you anymore.
Oh, sorry. I was at the issue of costs for enforcement. Now, there are 2 types of costs typically involved: the statutory fee and professional fees. Now, the issue of statutory fees is governed by the relevant rules of courts. Now, by the relevant rules of court, there are really minimal fees for whichever approach that the rules of courts recommends: motion on notice, originating summons, or motion ex parte. The fees are usually minimal. They're usually between $10 to $20. But in terms of professional fee, it's largely dependent on the lawyer's charge out rates. Typically, it could be as low as $5,000 to $20,000 for professional fees. Then in terms of chances for success, now the Nigerian courts are pro-arbitration. So far, you're able to fulfill the requirements as laid down by the relevant rules of courts. Typically, the arbitral award, the leave to enforce will be granted. Now, in terms of duration, there are no fixed timeline, but I think like it applies in Kenya. If it's not opposed, in 3 months, you get your application granted. But where it's opposed, within 6 to worst case scenario, 18 months, right? It should be granted. Then in terms of, also, there's also time limitations within which to bring an application to enforce an award. Now, though this is not provided under the ACA, it's provided by the relevant limitations law of each state. Now, for most of the states, it's 6 years. You must bring an application to enforce these awards within 6 years. However, an application to set aside an award must be brought within 3 months. I think I will just stop here and apologize for the technical hitches. I'm open to answering any question that, probably that the participants would have missed in terms of during the time of the technical glitch.
Well, there are some questions I can read in the Q&A box. First question to Darlington: has the arbitration bill become law yet? Is there a kind of arbitration bill, or is there a general Nigerian Arbitration Act? Could you please clarify, Darlington?
Sorry, I didn't get that, sir.
What is the law in place? Is it called Nigerian Arbitration Act, or is there any kind of new arbitration bill?
Okay, no, it's called the Arbitration Consolation Act. However, there's a new arbitration and consolation, a new arbitration act currently before the president for presidential assent. It is not yet been assented to yet, but it's been passed by both chambers of the National Assembly. But the new Arbitration Act is not yet in law, so we are still using the Arbitration and Consolation Act as in the LFN of 2004.
Thank you, Darlington. One additional question, which is already in the Q&A box. It seems that the Nigerian Arbitration Act, and I don't know if it's the old one or the new one, allows without further definition where there has been misconduct on the arbitrator's part or where the arbitral proceedings or award have been improperly procured to set aside the award. This seems to be very broad. What is your opinion on that, and how is this to be interpreted?
Okay, there are a couple of Court of Appeal and Supreme Court decisions that has defined what misconduct or improperly procuring an arbitration award means. It's quite a broad list. I will just refer to one authority and list out what the Apex Court said in that judgment, defined that misconduct of the arbitrator. And in the case of Taylor Woodrow Nigeria Limited versus Sudesti Ethnic Work GmbH, the court attempted to provide a list of actions that would amount to misconduct of the arbitrator. These acts were outlined as follows. 1, where the arbitrator fails to comply with the terms expressed or implied of the arbitration agreement, where even if the arbitrator complies with the terms of the arbitration agreement, the arbitrator makes an award which on the grounds of public policy ought not to be enforced, where the arbitrator has been bribed or corrupted. Technical misconduct, such as where the arbitrator makes a mistake as to the scope of the authority conferred by the agreement or reference, where the arbitrator umpire fails to decide all the matters that were referred to him, whereby his award, the arbitrator or umpire proposed to decide matters which have not been in fact included in the agreement or reference. If the award is inconsistent or ambiguous, or there are some mistake of facts, which mistake must either be admitted or at least clear beyond any reasonable doubt, where the arbitrator or umpire has breached the rules of natural justice. Now, in terms of improperly procuring award, the court has also, in another case, let me just refer to that case, Compagnie Generale versus Etuk, where the Court of Appeal held as follows. I will just read in verbatim. I agree with the appellant that the arbitral proceedings and the award were improperly procured. By the arbitration agreement, in clause 6 of the tenancy agreement, 2 arbitrators were provided for, but the respondent unilaterally procured a sole arbitrator who presided and made the arbitral award under circumstances in which its independence and impartiality could not be assured. So this is a typical example where the court has held that where in terms of composition of the arbitration panel, the rule or agreement in terms of composition of the arbitration panel was not followed. The court has interpreted that to be improper procurement of arbitration award.
Thank you for this answer, Darlington. There's one more question from Alessia Bulka, one of my colleagues. How is it in Nigeria? When trying to defend against the declaration of an arbitral award as enforceable, could you declare offsetting with other claims against the claim adjudicated in the arbitral award? So could you introduce another claim in order to defend yourself against the arbitral award? Would that be possible?
Sorry, can you take the question again? I did not quite get it clearly well.
There's an arbitral award, which...
Professor, can you take the question?
Let me try. The question, okay. Can you read it? This is the question from Alessia Bulka. You can read the question. The question is, there's an arbitral award which has decided that one party has to pay $100,000 to the other party. And now this party, who has lost the arbitration proceedings, tries to defend itself by offsetting with other claims. Would that be possible?
Yes, it's very possible. It's one of the grounds for applying for refusal of arbitral award or applying to set aside an arbitral award. It's clearly under our ACA.
Thank you, Darlington. Well, we have still 15 minutes. I can't see Kweko from Ghana. Let me ask him. Kweko, can you hear me? Yes, yeah, there you are.
I can hear you loud and clear, Professor.
And you are here, very good. So now it's up to you, but let me first introduce you. Dr. Kweko Einarsson is partner at AB Lexmore Associates, a firm of commercial lawyers and consultants in Accra, Ghana. His practice focuses on commercial litigation in the areas of tax, commercial transactions, and contracts. He was licensed as a foreign law consultant in the state of Georgia and the United States of America, where he provided advisory services to United States-based companies planning to do business in Ghana. Kweko is also a senior lecturer at the University of Ghana School of Law, where he teaches company law, commercial law, and natural resources law at the undergraduate level. He's also a core teaching member of the LLM in oil and gas program at University of Ghana School of Law. He's a member of the Ghana Bar Association with more than 19 years standing as a lawyer. And now he's going to present his experience and his knowledge on enforcing arbitral awards in Ghana. Please go ahead, Kweko.
Thank you very much, Professor, for that introduction. And I think it's still in the morning in Accra, Ghana. So I'll say good morning and then good afternoon to those of you that are in the jurisdiction where it is already past noon. Let me indicate that my colleagues from Nigeria, and also Kenya have essentially, summarized what I was going to say. And I think part of it is because of the fact that our countries, all three countries are actually part of the Commonwealth, and our legal system is similar, as well. So I'll just go ahead and give a quick, overview, and then I think I'll focus on practically what you need to do, before you prepare to bring an application before the court to enforce an arbitral award. So similar, in Ghana, just as in Kenya and also in Nigeria, all of us are contracting parties to the New York Convention. Specifically in Ghana, we have the ADR Act of 2010, and this is where the provisions on the enforcement of foreign arbitral award can be found. And in essence, Ghana is also a pro-arbitration jurisdiction. And essentially, once you have obtained that award, you take steps to register the award, and is then recognized as a judgment of the High Court. So in essence, what you're seeking to be able to enforce it, you must go ahead and have it recognized as a judgment of the High Court of Ghana. And once that is done, then you can go ahead and use any of the enforcement procedure that you would have otherwise used to enforce any other judgment, in Ghana for that matter. Now, I think it's also important for us to draw a distinction between what is referred to as a domestic arbitration award and then also a foreign arbitral award. And let me say that in Ghana, the difference or the differentiation is based on the seat of arbitration as opposed to the parties or the arbitrators in this regard. So once the seat of arbitration is outside of Ghana, then the award, the ensuing award, is then seen as a foreign arbitral award, which can then be brought before the High Court in Ghana for enforcement. In terms of procedure, it is the High Court of Ghana that has jurisdiction to enforce foreign arbitral awards, and you file an originating motion, which I think is very similar to what Darlington has said and my colleagues in Kenya has said as well. So you file an originating motion before the court. And let me say that this particular procedure is an expedited procedure to be able to get a decision from the court, because apart from that, you can go by a writ, and a writ is a much more longer, route. So the law allows you to file, an originating motion before the High Court. You serve, the defendant. I think I heard, my colleague from Nigeria saying that, that application in Nigeria is filed ex parte. In Ghana, you have to file it on notice. That is to say, you notify, the respondent in the matter. You give them, the law says at least, 3 clear days, for them to respond. In practice, usually, the notice is about 2 weeks, so that they'll be able to file, an opposition if they so wish, to do that. But before that application is filed, you will have to make sure that there are certain critical information that is before the court. And for the sake of time, let me say that it is in sync with, the New York Convention. So in essence, just what my colleagues have already alluded to. So I don't think there's anything different. So I will not add to that. In terms of the, the defenses that one can have with respect to challenging the enforcement of an arbitral award, let me say that is also not too different as well. So first and foremost, that award will have to be valid. It will not have been, must not been annulled in the country in which it was made. The respondent, you must also be able to demonstrate that the respondent was given sufficient notice to enable, the respondent participate in the arbitral proceedings in the first place. And if there's a party that was lacking in capacity, that you have to demonstrate that that party was given or was given the opportunity to be properly represented before the arbitral, tribunal. And then also it can be set aside if the award that was given did not deal with the issues that were submitted, for arbitration. So if the arbitrators went beyond, the issues that were submitted for arbitration, then of course the court in Ghana will not enforce, that. So these are the grounds by which, it can be set aside. Let me say that from a practical point of view, and in my practice, what you tend to see is that, foreign, lawyers would have contacted me after the arbitration award would have been obtained. And increasingly, I say this, to pose a lot of, challenges, because by the time that, the instructions are given, of course, there's not much that you can do to influence how the process itself is done before the arbitral, tribunal. So I think that's very important that you do not wait, till the tribunal has given the award before you seek, the help of counsel in the jurisdiction in which you are seeking, to enforce it. Because, for instance, if you look at the grounds under which, arbitral award will be set aside, in Ghana, one of the things that it says is that, look, the respondent, all right, should have been given sufficient notice to enable that party, that respondent, present its case before the court. Let me say that typically under Ghanaian law, or the Ghanaian court to tend to interpret the issue of whether or not the person has been given sufficient, notice based on, if you will, how our interpretation of what sufficient notice is. So it's very important that you are able to, contact local counsel to advise with respect to the process, itself before the arbitral award is given. Now, in addition, usually when the award is, when the foreign award is being enforced in Ghana, more than likely it will be because the respondent is resident in Ghana, or the respondent has some property that is located within the jurisdiction. So issues with respect to what will be the relevant address that will be used, that I think is very important that you contact local counsel ahead of time to be able to determine all those issues. I think it's also very important that you liaise with local, counsel, even when the proceedings are ongoing, to be able to determine the properties or the securities that we may want to go ahead and enforce the arbitral award, again. So if you wait all the way to, the award has been given, by the time that you start, the enforcement proceedings, if you're not lucky, the properties may have been dissipated, within the jurisdiction, or you may have even difficulty finding the respondent to serve them to participate in the processes before the court, the High Court in Ghana. So you may be able to get a favorable response from the court in Ghana, but you may find it a lot more difficult being able to enforce the judgment using any of the enforcement proceedings as I've indicated before the court. All right. Good. So in terms of costs, I think that is also not too different from what my colleagues have talked about. Filing fees are really, peppercorn. They are insignificant. So in terms of the cost of the application itself, anywhere between $100 to about $500 should be more than enough, to cater for government filing fees. And let me say that I'm giving a range because it depends on whether or not there are other intervening applications that are filed. But typically, between $100 to $500, it should be more than enough, in terms of costs of our filing. Then, with respect to timelines, because it is an application, but you can get it done as quickly as within a month. And sometimes when there are objections and when there are applications and all that, then can go anywhere all the way to about a year. And let me also indicate that when I speak about timelines in this regard, I'm actually speaking about timelines with respect to the application before the High Court. Now, once the High Court has gone ahead and granted the application for the arbitral award to be enforced in Ghana as a judgment of the High Court, the respondent has a right to appeal, has a right to go to the Court of Appeal and all the way to the Supreme Court as well. And I had one such case where we went all the way to the Supreme Court with respect to whether or not the respondent was given adequate time and whether or not the respondent was afforded was it afforded time to be able to get representation, if you will, before the arbitral tribunal, in this case was in China, before they were able to do that. So at the High Court, it can be very short, but of course, as of right, it can go all the way to the Supreme Court. And then when it comes to professional fees, yes, in Ghana, we also have a scale of fees that has been agreed to by the Ghana Bar Association, which serves as a guide with respect to fees. And here the fees can be either a lump sum, it can be an hourly charge, or it can be a combination of an hourly charge and then maybe having it capped at some point. So in essence, this is how a foreign arbitral award can be enforced in Ghana. Thank you very much.
Kweko, thank you so much. It's almost 2 p.m. So we have no time for any further questions. It's up to me to say thank you once again. Thank you to James, to Irene, to Darlington, and to you, Kweko. Thank you for sharing your experience, for sharing your thoughts with us. And I also say thank you to all those who participated and listened to us. This was the first webinar of this kind of issues, and maybe we will have further ones, including other countries. Thank you once again. Good afternoon. See you next time. Bye.